All right, court is calling 2023 CR 7730, State of Texas versus Jamarii Devon Simmons. If I have parties announced for the state,
Jason Garrett.
for the defense.
Charles Bunk.
All right. And counsel, you are here. You filed a motion to reconsider.
Yes, Judge. And I have copies of the motion if you don't.
Yes.
Okay, thank you.
All right, state, have you had a chance to review defense's motion?
Yes, no, I haven't. Oh. Yep, okay.
All right. State, do you have objections?
Yes, Your Honor, we object to any other sentence other than the 4 years that was discussed.
All right, defense, do you have any witnesses?
I do, Judge.
All right, you may call your first witness.
We'll call Gigi Hughes.
All right, Ms. Hughes. All right, can you raise your right hand? Good morning. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Gigi Hughes,
All right.
Gigihughes.
And for the record, state defense, I do know Ms. Hughes, we have not had breakfast, lunch, or dinner, or been to either's homes. No gifts have been exchanged. So is there any objection to the court hearing her testimony?
No, Your Honor.
All right.
No,
And
Judge.
Judge, I'm sorry.
No, go ahead.
And Judge, just to let the record be fair, I also do know Gigi.
Okay,
And likewise, no gifts or anything like that. And there's no objection from defense.
Well, I feel left out, but I don't object.
maybe we should have lunch. I don't know.
I would like that. May I proceed?
Yes.
Ms. Hughes, on behalf, you contacted my office and you indicated that you had a relationship with Mr. Simmons's family. Is that correct?
Yes.
And I spoke to you and I indicated that Mr. Simmons had been sentenced by this honorable court to a sentence of 4 years. And you said that perhaps you'd like the opportunity to address the court regarding that sentence. And so, are there some things regarding Mr. Simmons and his sentence you'd like to address to the court?
Yes, sir.
And if the court, if I may, I'd just like to expedite the process. I'd just like to let Ms. Hughes speak on Mr. Simmons' behalf.
Sure.
Okay, Ms. Hughes, go ahead.
Thank you. Okay, Judge, currently Jamarii is in CDL program. My son owns a trucking company. He works within that group of recruiting young men who might need to be steered back. But the most important thing is Jamarii has been raising his son, who's currently, I'm babysitting now in my home with my 5-year-old son. We're related through this family that Jamari's sister is the baby's mother to my grandchildren. So I know the family really well. But he's been working to really kind of steer his life right. I was most impressed with this fathering of his child. He's had his child since he was 5 months old. I know he was currently on probation. I know he goes to the classes that we're holding now at Sacred Baptist Church so that they can kind of steer and help with their anger. But I don't know if Jamarii attended the first 3, but we're going to get him back in that program. And we're going to ensure that he gets his CDL. I think he needed 3 more weeks to complete that. But because of the monitor, I think it limited some of his time. But, oh, I talked longer when I said I swear. Oh, I'm sorry. So what we're doing now is just currently working with him in the community with the program that I wrote a grant for. So hopefully we can get him. Well, he is on the right track. Just that incident that happened that we are trying to make sure we keep him straight, especially for his son's sake.
Ms. Hughes, if the court was to grant our request and reconsider his sentence, would you continue to assist Mr. Simmons in his road to recovery and continue him to help steer him in getting back on track and help him continue to raise his son and be a good father and be a good contributor to society?
Yes, most definitely, because we do check with them once a week, once they get back in that CDL program. And I think there's some more classes that he's currently taking. His mother knows more about those. So he was on the track, you know, it's just that track and he got steered off really fast. Just things happen that he just didn't control.
And you have been in contact with his family while he has been in TDC, is that correct?
Yes, yes.
And his mother's here also today, is that also
Yes,
correct?
actually, his son is at my home now with my 5-year-old grandson. So,
Anything else you'd like to tell the judge on behalf of Mr. Simmons or that you think would help her as he makes this decision today on the many different things she could do to help Mr. Simmons in this situation?
no, yeah, but we will monitor him once a week. We will stay in touch with him and check on the baby. Truth is the baby's name, but we will check with him every week and make sure he's doing okay. A lot of positive interjection there, so they tend to work out. I've had no repeats so far. Thank God, but it's working pretty good.
All right.
That's all I have, Judge.
All right, any questions?
Just a few questions.
Yes, sir.
I mean, one, you don't know any of the facts about the case, the aggravated assault that we got to read.
Well, yes, I know a little bit.
A little bit of it.
I know his car was being vandalized.
And do you know the victims associated with this case?
No, I don't.
Okay. And you don't know that was actually convicted of a burglary of a habitation years ago. Are you aware of that?
No, I know he had some juvenile issues,
Right.
but that's why we were trying to steer him before he really.
And that's what I'm speaking of. He
Right.
actually had a burglary of habitation that's juvenile, but then he also was on probation for possession of marijuana, 4 ounces to 5 pounds. Are you aware of that?
No.
Thank you very much. No further questions.
Okay.
All right,
That's
thank
all I
you
have.
so
All right,
much.
thank you, Judge.
Thank you, ma'am.
Thank you.
Thank you.
Thank you.
And I'd call his mother Miss Simmons.
All right, Ms. Simmons, if you come forward. Hello.
Hello.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the
Okay.
record.
April Simmons.
All
May I
right,
proceed? Thank you.
yes.
Ms. Simmons, I know you've spoken to the court before regarding your son. And I would like to briefly talk to you. Have you had a chance to remain in contact with him since he's been in the prison system?
Yes.
And have you seen changes in him and his attitude since he's been incarcerated?
Yes.
And can you briefly describe for the court some of the changes you've observed? Or have you seen him in person or just talked to him on the
Just
phone? Okay, can you kind of tell the judge what you've heard or what you've noticed as you've spoken to him?
Just pretty much, he's in good spirit, but his energy like this. I don't know how to explain it, but it's different. I can tell the difference. Like, he got his head on right. He just got good energy. I just tell it, I just know the difference with the conversations that we have. But like I say, most importantly is it's about his son. And then I have to get emotional. But also, I don't know if it matters or not, but like right now, our family is going through a lot because since Jamari has been incarcerated, we just lost my nephew. He just died on the 5th with the shooting that occurred recently. And then I have another nephew that's fighting for his life. So at this point, I just wish Jamari can be at home because it's a time like I just want all my family together, pretty much. I did, but I can't tell the difference. Like I say, he got his head on right.
Now, you realize today we're asking the court, there's several things the judge could consider at this point. She could, if she chose to, she could reconsider her decision and grant him the probation we originally asked for with all the conditions that we presented to the court on that day. She could reconsider her sentence. She could potentially grant him the credit for the 238 days he wore the monitor while he was awaiting her decision. There's lots of things she could do today, and we would of course appreciate any consideration she gave us.
Yes.
But let's talk just briefly about True, his son, and how old is he now?
5.
And when we were before the court on the day that she made her decision, we told the judge he was the sole provider for his son, is that correct?
Yes, yes.
And so what's happened to True since then? Where does he live? Who's taking care of him? What's his status?
He stays with us, but with me and with me and my family. But since it's the summertime, like he just goes to Miss Gigi house or he go to my daughter's house. So it's with the family. It's just because everyone has children with his cousin and them, so we try to just keep them all together. But he's in a stable environment. It's just we got a lot of siblings, so he goes from cousin to cousin or at my house mainly. He's just amongst with the family.
And it's your hope that if the judge was to reconsider, that Drew could be back with his dad could go back to getting back to work.
Yes,
And at least that part of Drew's life could be somewhat more stable.
yes.
Anything else you'd like to tell the judge before, as she considers our request? I know you're nervous and I know it's hard. And I understand that.
I just hope he can come home or just be back with the family. Just do the right thing.
That's all I have, Judge.
All right, any questions?
Yes, just briefly, Mr. Simmons.
Yeah.
I mean, one, you're aware that your son had a previous conviction, juvenile for burglary of a habitation. And that was in 2013, and then he was adjudicated on that in 2017. And then at that time, he actually, in 2020, he was on probation for possession of marijuana, 4 ounces to 5 pounds for deferred. Are you aware of that?
Yeah.
And are you aware that on that day of possession of 4 ounces to 5 pounds, that happened on May 31st, 2019? Around that time. I know you probably don't know the exact dates,
Yeah.
but you aware that in the commission of that possession of that marijuana, he also had a handgun in possession at that time.
If I can remember, like I believe, I don't know how actually with the marijuana and the handgun, he was from my understanding, it was supposed to be some kind of a different identity thing. So he was supposed to be fighting the charge from what I know from them two charges.
Well,
So it was supposed to have been a mistaken identity for that.
well, you did plead to that and took 4 years deferred. Are you aware of that?
Mhm.
And in fact, at the time of the commission of what he's currently serving prison time for, this ag assault, he was actually on deferred for that possession of marijuana. Are you aware of that?
Yeah.
Okay. And so going to the ag assault that he's currently sitting in prison for 4 years, are you aware of any of the facts on that case? Did you speak with your son about the case?
To be honest, no, I mean, to be honest, I didn't actually speak to him because like my son don't try to bring a lot of negativity to me, but like for support, I just try to.
Of course. I mean, you're his mother. I mean, you should support him all the way, no matter what happens. And I'm not faulting you for that at all. I was just asking, in general, did you have any knowledge? And you're saying you don't because you didn't really discuss that with him. Is that right?
Yeah.
Okay, ma'am. Thank you. No further questions, Your Honor.
Thank you so much.
Thank you.
That's all the witnesses I have, Judge.
All right, the court will hear brief argument.
Oh, yeah, the judge, state over first. State's still in the position, Judge, that, I mean, assessing 4 years, Texas Department of Corrections for this individual for the crime that was committed is appropriate. It's actually on the lower side of any type of sentence. So we believe that the 4 years sentence is appropriate in this case.
Mr. Brock?
Judge, first, we appreciate the court giving us the opportunity to be heard. We do believe that, as we said the day that you sentenced him, there were lots of things available to the court. And I'm sure the court still has in its possession the list of things we proposed that day. Of course, we would love for the court to consider bringing him back and placing him on supervision. If that's still not something the court would consider, we would appreciate any consideration the court could give to either one, reconsidering the number of years sentencing him or in the alternative, potentially giving him credit at least for the 238 days that he wore the monitor while he was awaiting the resolution of these cases. But that's our request, and we appreciate your time.
Thank you. So, to his family, I want you to know that when I sentence people to prison, I don't do that lightly. I don't just throw out years. I don't say, 20 years, 30 years, and just forget about it. There is a reason behind the years that I sentence people. For example, they may be someone who's before me, who's charged with an aggravated assault with a deadly weapon. They may end up with 2 years, or they may end up with 10 or maybe 20. Everything for me is on a case by case basis. And I do remember this case because I remember all of the cases that come before me. And there are a host of things that were going on. And that's the reason for the 4-year sentence. And I think that was an appropriate sentence for him. And we can go off the record. Your argument and your motion is denied.
Would you consider the request for the 238 days credit while he was on the monitor?
No. All right. Thank you.
Thank you, Judge.
Thank you.
May we be excused?
All right. Thank you. You
Thank
did a great service to your client.
Thank you, Judge.
Will Brooks, who are you here for? All right. Vincent Alfonso.
Yes.
All right, State, have you had a chance to review the defense's motion?
I have, Your Honor.
All right, the court is going to go on the record in night mag number 760861, State of Texas versus Vincent Alfonso Jr. Can I have parties announced for the record for the state?
Harrison State.
Will Brooks for Mr. Alfonso Jr., Judge.
And are you Mr. Alfonso Jr.?
Yes, ma'am.
All right, defense has filed a motion seeking a bail reduction due to delay. State,
Yes, Your Honor.
you may proceed. Do you have any argument? Defense is stating that, of course, he needs to have his bond set to a bond he can make because of the delay. So is there any bond amount that he can make, or are you asking for a PR bond?
I'm asking for a PR bond, Judge. He's indigent. He has been incarcerated prior to Bexar County. You were in another county? But he is indigent, Judge. I'm appointed. I can tell you quite frankly why I'm asking for a PR bond too, Judge. He has some out-of-county warrants. I think there's a total of 4. They're out of Dallas County is my understanding. And the charges are more significant than here. So my thought is they come and pick him up and he's able to work through those matters up there.
Okay, so before we do that, State, do you know about these charges out of Dallas County?
I only know what Mr. Brooks has relayed to me, that at least 2 of them are robbery cases. With bonds totaling 175,000 when all are taken together. I know that in this felon possession firearm, this case was reassigned to ADA BOSIS on July 12th of 2024. I am also vaguely aware that our new case management system has hindered my office's ability to correctly calculate the amount of time that people are confined in the jail from the point of their arrest. So I don't know when or if Mr. BOSIS will get to this case in a timely fashion.
I can,
Yes.
if the court will permit me, I can show you where I found on Tyler that it shows he's actually booked in on those out-of-county warrants. It shows bail amounts. It just doesn't show a charge description.
All right, so my question is, what date was he booked in?
Oh, he was booked on, let's see, 4/15.
No, arrested the 3rd.
All right, so this is what we're gonna do. Time out. Everyone, we're gonna take our recess. And what I'm gonna need to know is when he was booked into the jail so that I can calculate and all parties can calculate whether or not it is actually 90 days or not.
Can I show the court my Tyler? It shows at least where it's saying he was booked and that's been at least 90 days, even if this date is.
Okay, I appreciate Tyler, but I do.
get that too.
Don't know Tyler's last name, but I appreciate Tyler. So we're off the record. What we're gonna do is we're gonna contact the jail. If nobody has any objection, I'll contact the jail and we'll see when he was booked in at the jail. And, or either the state or the defense, you all can call the jail see when he was booked in at the jail, and we'll start the calculations there. I know there's an issue with our current system. Even the clerks can't calculate the dates on there because nobody who installed the system asked for that because they didn't talk to the people who would actually be using the system. But that's an argument for another day. So we're going to take our break and we will be back at 1:30-ish.
Understood.
And Mr. Brooks, if you can't be here in person, if there's no objection for this from the state, you can Zoom in.
There's no objection from the state, Your Honor.
All right, so you can Zoom in.
Okay.
Yours too.
All right, we're going to go back on the record in NIMAC number 7600861, Vincent Alfonso Jr. If I can have parties re-announce, please, for the state.
Will Brooks for the defendant, Mr. Alfonso, Judge.
All right, and you're Mr. Alfonso.
I'm Alfonso Vincent.
Okay. All right, so where we left off is whether or not the defendant has been in custody past the 90-day mark. And defense?
Judge, he is at 94 days in custody.
Okay. All right, so he's entitled to a bond that he is able to make. And so the current bond is at $15,000. And I know we started, but do you wish to call your client with regards to a bond amount that he's able to make?
If I may for that purpose, Judge.
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Vincent.
You may proceed.
Alfonso, the court has to make a determination as to whether to reduce your bond or potentially give you a personal recognizance bond today.
Yes, sir.
So I'm appointed to represent you, correct?
Correct.
Do you have the ability to make the bond at $15,000?
No, sir.
Do you have bank accounts?
No, sir.
Do you have cash?
No, sir. I've been locked up.
How long have you been locked?
I got locked up April 3rd, so it's been over 100 days.
And is there any family member, anybody that's able to make the bond at a current amount?
No, I'm not from here.
Is there any amount of bail that you or a family member could make?
Not sure. I'm not sure.
But as it stands right now, you're incarcerated. You have no money to make bail.
Right.
And no way to make it.
Right.
Thank you.
All right, any questions with regards to bond amount in the state? All right, I just have a few questions. So have you ever been diagnosed with any mental health issues?
No, ma'am.
Have you ever been on any type of medications?
For mental health?
Yes.
No, ma'am.
Have you ever been on any type of medications for medical reasons other than mental health?
I'm a diabetic.
All right. And any drug use?
No, ma'am.
All right, thank you. All right, state, what are you requesting? All right, defense?
Judge, I'm just asking for the court to consider a personal recognizance bond. If not, then to consider the state's request.
So what I'll do is I'll set the bond at the bond amount requested by the state. This one. We don't have the order attached, but I'll write an order. All right, I'll set your bond at $1,500. Any conditions being requested by the state?
Judge, my only issue with that is, should he make bail, my expectation is that he's going to be picked up by law enforcement and transported to Dallas County. So my worry is that stops that from happening somehow.
Okay.
But I mean, maybe if the court would order within 7 days of release.
All right, I'll do GPS, waive fees, and GPS. I'll order full GPS, waive fees. GPS to be installed. Within 3 days of release from custody. And counsel, if for some reason he's immediately transferred to the other county, just let the court know.
Understood, Judge.
And then that may change the court's order.
Okay, thank you, Judge.
All right, is there anything else? You're welcome. All right, Ms. Ferguson, on Mr. Alfonso, just give him a court date in 45 days.
Yes, ma'am.
Thank you.
Thank you, Judge.
You're welcome. And if you'll give him the reset form.
Yeah.
All right, who's here on Jennifer Wilbur? All right, if you'll come forward, please. Hello.
Hi.
All right, court is calling 2024 CR 067462W, State of Texas versus Jennifer Wilbur. Can I have parties announced for the record for the state?
Christopher Ramos for the defense.
And are you Miss Wilbur?
Yes.
All right, Ms. Wilbur, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes.
Did you understand that by entering this plea bargain agreement, you are waiving the right to have a grand jury hear the facts in this case and make a decision on whether or not to hold you over for indictment?
Yes.
I'm sorry, hold you over for trial. Did you understand you're also waiving certain rights that your attorney has, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes.
Did you understand that by entering this plea bargain agreement, you were giving up those rights that I've explained to you? And counsel, did you explain this document to your client?
Yes, ma'am.
And Ms. Wilbur, did you sign this document?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.05 and 26.03 of the Code of Criminal Procedure. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the information with your attorney? Did you understand it?
Yes, it is.
Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you understand by information you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? And did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, and she was.
Ms. Wilbur, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's $1,000 fine to be probated. State is recommending deferred adjudication. This is to run concurrent with 716927. They will take in consideration 723334. There's to be restitution of $5,139.17 and cause number 72334 to Teresa Shields. Did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes, ma'am.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
And it is- that is your-
No objection.
All right. Did you review the document? State, you may be excused.
Thank
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Yes, ma'am. I can offer that my client earlier this year, she participated in the Pay It Forward program at the Hope Residential Center. She began that program in February 2024. She was released from that program and completed it in the spring. That's when I met her. Around that time, I received information from lifetime recovery counselor, Ms. Kelly. She provided information to me and she described Ms. Wilbur as having a better understanding of what substance abuse is and how it's disrupted her life. Ms. Weber is currently also participating in receiving services with the San Antonio Council on Alcohol and Drug Awareness. She's been associated with that program since April 24th, 2024, and her recovery coach writes that Ms. Jennifer is doing very well on this program. So it does seem that as early as earlier this year, she's been doing very well, doing her best to get her hands around the substance abuse issue. And we anticipate good things from Ms. Weber as she continues on this deferred.
Okay. So, do you have any family support in San Antonio?
I do. My dad's here with me and I have my daughter, my sister, my brother.
Okay. And do you stay with them or are you staying at Lifetime?
No, I'm staying in a sober living dorm.
Okay. And are you employed?
I am.
And what do you do?
I work at the front desk for a hotel downtown.
Okay.
And that's a brand new job for her. She just got it.
Congratulations.
Thank you.
That's all. Jobs can be stressful because when you're at the hotel, sometimes people are upset that the room is not ready on time and all of that,
Yes.
but I'm sure you will handle it well. All right. Do you have any children?
I do. I have one. She's going into college in the fall.
Oh, awesome. All right. This is what the court is going to do. Court is going to sentence you to $1,000 fine. That will be probated. 4 years deferred adjudication. If you complete everything early, the court will consider releasing you early. This will run concurrent with cause number 716927. taking consideration 7233334. There's to be restitution to Teresa Darlene Shields, SHIELDS, of $5,139.17. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. She's to continue living in the sober living house. We'll do a TAP evaluation out of custody. Probation, if TAP recommends inpatient treatment, we'll start with outpatient treatment. Are you doing any sober meetings?
Yes, I do 5 a week.
Oh, that's good. All right. So here's the thing about sober meetings. I always require sometimes, not always, but sometimes I think I see people and I'm like, you need to do sober meetings. So what I'm gonna do is I'm gonna place you at 4 sober meetings a week. If you want to do 5, you can do 5. The fact that you do more than the sober meetings that I'm requiring of you is not going to be a detriment to you, because your goal in this probation should be finding out what you need to do to maintain your sobriety. And if taking 5 a week means you maintain your sobriety, it's not going to hold you back from early termination, okay? So there's going to be 4 sober meetings weekly. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, there'll be 1 field visit just to find out which sober living place she is. And then thereafter at probation's discretion, 120 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. Just give me 1 second. In this courtroom, communication is key to be successful. If you ever think that you're going to pick up the phone, call your probation officer and say, I'm thinking about using. And then that way probation can get you some help. If you call and there's no answer and they're not addressing it, you can always come back to the court and address it with me here Monday through Friday, okay? All right, good luck to you. All right.
Thank you, Judge.
You're
May we
welcome.
be excused?
Yes.
Thank
Well, once probation goes over.
Yes, ma'am.
Yes. All right. Who is on Alberto Hernandez? All right.
A little more closer. And when you speak, make sure you speak loudly and don't say, don't nod your head. Make sure you say yes, no.
Yes, sir.
All right. Court is calling 2024 CR 4387, State of Texas versus Alberto Navidad Hernandez. Can I have parties announced for the record for the state
The honor for the state.
defense?
The attorney record is Monica Guerrero. Joseph Stateson standing in to cover. And Mr. Hernandez, will you give this court permission for me to do this in place of Ms. Guerrero?
Yes, sir.
All right. And you're Mr. Alberto Hernandez?
Yes, ma'am.
Counsel, have you received all the discovery that you reviewed with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review what's entitled application of community supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Both counts?
Yes,
Did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Let me see. All right. Did you understand in each count you're charged with online solicitation of a minor as a third-degree felony?
Yes, ma'am.
Range of punishment in each count is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments to be assessed at 8 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication, and the state is opposing your application. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Can you repeat it one more time, Your Honor? There was some clarification Mr. States and I were talking about earlier.
All right. It says punishment to be assessed at 8 years. There's a $2,000 fine. There's no application for deferred adjudication, and the state is opposed to the community supervision.
Yes, Your Honor.
All right. Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motion?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest. Five.
To count two, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence to support the plea?
State offers State's Exhibit 1 in all attachments.
No objection, Your Honor. My client's asking a question. Can I
Yes.
step back just a moment?
Sure. All right. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports?
Yes.
But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. So my question. With regards to count 1, maybe I'm missing it in the documents. I see evidence of count 2. And so I'm just trying to find the evidence in there of count 1.
And Your Honor, may I put something on the record at this time?
Yes.
I had explained to Mr. Hernandez, Chapter 62, sex registration,
Mhm.
and how online solicitation of a minor in Chapter 62 is a reportable conviction.
Yes.
It requires registration. Although the plea bargain page does not indicate that, it's an operation of law that would be
Yes.
effective. So I just wanted to let the court know, we did discuss this. I did admonish Mr. Hernandez, and I explained that he would have to register. That's part of the plea, even though it's not actually on the plea bargain page.
Bless you.
Thank
God
you.
bless you.
Mr. Hernandez, I haven't mentioned the Chapter 62 registration because I have to see the evidence first. And so once I see the evidence, if I find that it is sufficient to find you guilty, then you will be required to register.
May I step back a moment with the prosecutor also?
Sure.
Regarding the
And it's regarding the statement that is in count one.
statement count.
Yeah, she.
Miles, come forward.
What's your middle? Marie,
All right, so what's your full name?
my married name was Marie Therese Miles, but I didn't notice when they arrested me a year ago, when they gave me the inmate card, it said Nyaha on there for some reason, but it's my maiden name. I don't
Okay.
know how they
Your
came-
maiden name?
My mother's name.
Oh, not,
All right.
I thought you said middle name.
So here's the thing, state has filed a dismissal. The reason why they're dismissing it, they're not saying that you didn't do it. They're saying they're dismissing it because the complainant in the case has waived prosecution. So I don't know anything about the facts of this case because I would only know about that if the motion to suppress was filed or if you all were in a jury trial. So what I can tell you is this is a family violence case. Whatever issues between you and the complaining witness that brought you to court today, whether they wanted this case dismissed or not, those issues are still there. And they're going to rear their heads when this case is done and you and the complainant leave, if this was that type of relationship, and go home, those issues are still going to be here. So you all maybe want to go to therapy to figure out what your issues are. And then you need to make a decision. Do you want to stay in a relationship like this or not? And if the answer is no, then people need to part ways. Because I'm a firm believer, anytime you're in a relationship, when people want to start putting their hands on people in violence or whatever, maybe it's time for that relationship to be over. And when people think that people are cheating on them, you have two choices. You either accept it and stay in the relationship, or you say, thank you, I think you're cheating on me, the trust is gone, this relationship is over, and move on. Those are your choices. So here's your dismissal, and hopefully we don't see you back for this again.
And I don't think you ever will. But thank you,
We're
Judge.
gonna put you on the record with that.
Thank you.
You're welcome.
Some confidence.
I do too. I think she's gonna be fine. Good luck to you.
Thank you.
Oh, and it's raining outside. Already on Alberto Hernandez?
Yes, Your Honor.
So were you all able to find what I could not find?
States amended States Exhibit 1 and has presented it to defense counsel for objection.
I reviewed the additional, I believe it's 3 pages. It would substantiate the count one, the evidence. It is what it is. I know that there's text and graphic picture. It is part of the offense. That is the stipulations, and we don't object to the stipulations.
All right, I'm assuming it's amended where the green tab is that correct?
It's the final 3 pages, Your Honor.
Okay. Okay. Well, I didn't need the last picture, but okay. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of count 1 and guilty of count 2. And we will come back on September 12th. At that time, the court will make a decision on your application for community supervision. That will be based upon any evidence that is presented to me and also the PSI report. Is there going to need to be a TAP evaluation as well or no?
At your discretion, Your Honor. I don't believe substances were involved in this offense, but if any additional evaluation could be helpful.
All right, we'll do a PSI and TAP evaluation. All right, once you speak with probation and sign the reset form, you're excused.
Thank you, Judge.
Ma.
All right, you're welcome.
Yes.
All right, who is here on Nelda Rios? And where's Miss Rios? Court is calling 2022 CR 11792, State of Texas versus Nelda Rios. Can I have parties announced for the record for the state?
Andrew Barrett, Salem.
Defense?
Albert Chitis for Ms. Rios?
Are you Miss Rios? All right. Are there any applications in this case?
No, they're not.
All right, Ms. Rios, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you understand by indictment, you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? All right, according to the plea, punishment is to be assessed at 14 months in the state jail facility. There are no applications. The state will take in consideration JN number 6785865. Did you understand that to be the plea? Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
And an exhibit.
No objection, Your Honor.
State you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Did you?
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that she does have approximately 329 days for county jail credit. We would just ask to have credit for that.
All right. So, and I'm sorry, Ms. Rios, you entered a no contest plea, correct? Okay. I'm sorry, you were whispering. It was hard for me to hear. So, do you have a place to live when you're released?
I'm homeless.
Huh?
I'm homeless.
All right. So, what are your plans? I mean, there are places that you can stay. There are sober living places because obviously you have drug issues. So, have you looked into that?
Oh, just like God take me.
All right, so here's the thing. I understand when people say they're gonna let God take them where he wants to take them, but God gives you senses, right? And so you got to do your part. There's a story that people always tell where somebody was drowning and somebody came by in a boat saying, hey, let us help you. You remember this story?
Yeah.
And the person's like, oh no, I prayed, God gonna come save me. Then helicopter. Oh no, don't need any help because God is gonna save me. Person ends up drowning. And it's like, God, why didn't you save me? And it's like, I sent you the boat, I sent you the helicopter, I sent all these people to help you, and you didn't want it. So you're gonna have to do your part too. And there are places where you can go for free when you're released from custody. If you can't find those places, you can come back here. If I'm still here, I'll tell you the different places you can go. They even have a community court that can help you with housing. But this location where that person told you leave and not come back, you can't go back there. You understand? All right, the court, as previously stated, is finding you guilty. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, taking in consideration JN 6785865. Yes. And there is to be no contact with the Ariba, ARRIBANEN, Blanco, BLANCO apartments at 5200 Blanco Road, San Antonio, Texas 78216. And I request the therapeutic community. Therapeutic community will not increase the time that you are in custody, but hopefully they can help you maintain your sobriety when you're released. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you.
You're welcome.
Thank you, Your Honor.